one proposal allowing them to carry firearms without a license.
The bill allows gun owners 21 years and older to carry a weapon in Tennessee without a permit.
21 years and older who are allowed to own a handgun will no longer need a license to carry it.
Picture this. You wake up tomorrow morning and the firearm permit you've been carrying for years is suddenly worthless. Not because you did anything wrong, but because the highest court in the land just declared that the entire system requiring you to ask permission to exercise a constitutional right is fundamentally flawed. Sounds impossible, right? Except it just happened. And what makes this even more shocking is who's supporting it. The very government agencies that spent decades enforcing these exact rules. A unanimous Supreme Court decision just sent shockwaves through America's legal landscape, and the implications are so massive that even seasoned legal experts are struggling to grasp the full scope. This isn't some narrow technical ruling that only lawyers care about. This is a fundamental redefinition of how gun rights work in America, and it's already triggering a cascade of changes that nobody saw coming. States are scrambling. Law enforcement agencies are confused. Gun control organizations are in panic mode. And a billion-dollar industry built around permits just watched its foundation crumble in real time. Here's what nobody's telling you. This moment has been building for over a century, and what just broke isn't just a legal precedent. It's an entire philosophy about how rights work in America. For more than 100 years, states operated under a simple premise. They could require citizens to obtain permission before carrying firearms, whether concealed or openly. The system seemed reasonable on the surface. Apply for a permit, pass some checks, maybe complete some training, and you'd receive government approval to exercise your Second Amendment rights. Millions of Americans went through this process without questioning the fundamental logic. But here's the problem that just got exposed. Constitutional rights aren't supposed to work that way. The Supreme Court just clarified something profound. The right to carry a firearm doesn't begin after bureaucratic approval. It begins with the Constitution itself. Permits create delays, impose taxes, and most problematically, introduce subjective approval systems where government officials get to decide whether you deserve to exercise your rights. That model just got declared unconstitutional at its core. The court essentially said that a shall not be infringed right cannot be locked behind a bureaucrat's discretion, regardless of how well-intentioned that bureaucrat might be. Think about what this means. Imagine if you needed a permit to exercise free speech, granted only after proving you had a good reason to express your opinions. Imagine if you needed government approval before practicing your religion, or if you had to justify why you needed protection against unreasonable searches. We'd recognize those scenarios as obviously unconstitutional. The court just applied that same logic to the Second Amendment, and the legal earthquake is still reverberating. Now here's where this story takes a truly bizarre turn. The Department of Justice didn't fight this ruling. Let that sink in for a moment. Historically, the DOJ has opposed virtually every case that expands Second Amendment protections, throwing its considerable legal weight behind restrictions and permit requirements. But this time, they quietly stepped aside. Internal memos cited in court filings revealed something stunning. DOJ attorneys themselves believe permit systems had become legally indefensible after previous Supreme Court decisions. They essentially admitted that trying to defend these systems would be futile and potentially embarrassing. Even more remarkable, 15 states joined amicus briefs supporting the shift away from permit requirements. These weren't all red states either. The coalition included states that had previously defended their permit systems, but recognized the writing on the wall. When even the federal agency responsible for enforcing gun regulations declines to defend those regulations, you're witnessing something unprecedented. The very system that prosecuted permit violations for decades just acknowledged that the foundation was rotten all along. Constitutional carry, the concept that law-abiding citizens can carry firearms without government permission, wasn't invented by this ruling. Over half of U.S. states already had some version of it. But those states existed in legal uncertainty, constantly facing lawsuits, federal interference, and hostile judges who claimed their laws violated some vague public safety interest. Not anymore. This ruling didn't just validate constitutional carry, it provided federal legal protection that makes challenging these laws nearly impossible going forward. Blue states that have spent years building complex permit infrastructures are now legally vulnerable in ways they never imagined. Future attempts to reintroduce permitting will likely get struck down almost immediately, with this precedent hanging over them like a legal guillotine. This is the green light that constitutional carry advocates have been waiting for, and the practical effects are already materializing at breathtaking speed. California, New York, and Illinois, the three states with perhaps the most aggressive gun control frameworks in the nation, are in full crisis mode right now, and they have every reason to panic. California's discretionary may issue system, where officials could deny permits based on subjective criteria, is dead on arrival. New York's strict concealed carry permit system, already damaged by previous court decisions, now has no legal foundation whatsoever. Illinois, still reeling from litigation over magazine restrictions, is now facing a tsunami of lawsuits targeting its entire permit scheme. The fallout started within hours. Lawsuits were filed in California within 24 hours of the ruling, challenging not just permits, but associated training requirements and restrictions on where people can carry. Sheriffs in rural counties across multiple states publicly announced they would refuse to enforce permit checks, citing the Supreme Court decision as justification. Gun rights organizations, armed with an unassailable legal precedent, launched coordinated campaigns to dismantle state-level restrictions piece by piece. This isn't hypothetical future action. This is happening right now, and the pace is accelerating. But here's an angle most people haven't considered. There's a billion-dollar industry built around gun permits, and it just took a fatal blow. From application fees to mandatory training courses to renewal processes and background check systems, an entire economic ecosystem existed to manage the permission process. That empire is collapsing. Revenue from permit applications is evaporating in red and purple states. Concealed carry instructors are watching their businesses implode as mandatory courses become optional. State-level databases tracking permit holders are losing their legal justification for existing. This was never purely about safety. It was also about money and control. Application fees generated substantial revenue for state and local governments. Training requirements created a captive market for instructors. The bureaucratic infrastructure employed thousands of government workers. And most importantly, the discretionary nature of some systems gave officials tremendous power over who could exercise their rights. All of that is evaporating simultaneously, and the economic and political fallout is only beginning. Some states aren't just celebrating this decision, they're moving with remarkable speed to lock in its implications permanently. Florida's governor ordered the elimination of concealed carry permit requirements by year's end, framing it as a constitutional correction long overdue. Montana and Texas passed emergency legislation expanding where constitutional carry applies, including locations previously designated as off-limits. Tennessee's Attorney General issued statewide guidance declaring all local permit requirements void under the new constitutional interpretation. South Carolina and Alabama are considering state constitutional amendments to enshrine these protections beyond any future court's ability to overturn. These states aren't merely reacting, they're building legal fortifications designed to withstand future challenges. They're writing laws that will be exceptionally difficult to strike down, even if the political climate shifts. And perhaps most significantly, they're proving that when constitutional barriers fall, change happens at lightning speed. Meanwhile, law enforcement agencies are caught in bureaucratic chaos. Police departments and sheriff's offices across the country exist in legal limbo. Some departments still demand permits despite the law changing, creating tension with state attorneys general and sheriffs who understand the new legal landscape. Local prosecutors are dropping charges related to permit violations en masse, terrified of the civil lawsuits that could result from prosecuting people who were exercising now recognized constitutional rights. Constitutional sheriffs in counties across Arizona, Georgia, and Idaho have publicly declared they will not enforce permit requirements, period. This is a rare moment where federal law, state policy, and local enforcement are completely misaligned, and citizens are navigating the confusion in real time. Carry permit enforcement isn't gradually declining, it's collapsing suddenly, and nobody knows exactly what the rules are in their specific jurisdiction anymore. Gun control organizations responded with predictable fury and surprising strategy. Within hours of the ruling, they launched massive PR campaigns, emergency fundraising drives, and drafted new legislative proposals designed to work around the decision. Major anti-gun groups called the ruling a national disaster and pledged tens of millions of dollars to fight it at state levels. Their strategy? Introduce new training requirements as workarounds to direct permitting, classify more areas as sensitive places where carry is prohibited, and essentially make carrying so legally complicated that most people won't risk it. Here's the problem with their approach. None of these measures can survive long-term scrutiny if they violate the court's core reasoning, but expect a protracted legal chess game where restrictions get repackaged, redefined, and defended using creative arguments about public safety and historical tradition. The war isn't over, it just shifted to new terrain. This ruling exists within a larger historical arc that's been building for nearly 2 decades. It builds on the foundation of Heller in 2008, which affirmed an individual right to bear arms. It extends McDonald from 2010, which applied that right to states through the 14th Amendment. It continues the momentum of Bruin in 2022, which demanded that gun laws meet a rigorous historical test. And now it applies that test directly to carry permits, creating a precedent that's virtually impossible to reverse without abandoning the entire constitutional framework. We're witnessing the end of a decades-long strategy by gun control advocates who hope to outlast favorable courts through persistent state-level restrictions. That strategy just failed catastrophically. The court isn't catching up to public opinion. It's leading a constitutional restoration, declaring that gun rights aren't negotiable gray areas, but guaranteed freedoms backed by America's highest legal authority. So what happens next? Massive litigation against remaining permit systems in blue states, expansion of carry rights into previously restricted zones like parks, public transit, and government buildings, federal lawsuits against states that attempt retaliatory workarounds, and likely additional Supreme Court clarifications on sensitive places, accessory regulations, and related restrictions. The map is shifting permanently and faster than anyone predicted. A permitless future that seemed like a fringe fantasy 5 years ago is now becoming mainstream reality, backed by federal law and spreading state by state. The question isn't whether this will continue, it's how fast, and whether your state will lead the change or get dragged into it kicking and screaming. Either way, the era of asking permission to exercise constitutional rights just ended, and what comes next will define American gun rights for generations.